I'm Mitchell. I'm from the University of South Carolina. I don't have much of a southern accent because I'm actually from Minnesota. Was a public school teacher in Minnesota for 16 years, got a Ph.D. at the University of Minnesota, moved to South Carolina with a full intention of staying 2 or 3 years, coming back to Midwest, and that was 28 years ago. So didn't quite work out. But I must say, especially after your last winter, I really enjoy the winters in South Carolina more than I do in the Midwest. But at any rate, my area of expertise and the area I'm most interested in is legal issues. And I was a due process hearing officer in South Carolina for a number of years. And then we have a kind of a funky system where we have what's called two-tiered. So now I'm a state review hearing officer in addition to being at the University of South Carolina. So I've always been very interested in legal issues. And I'll let David introduce himself right now.
Hi, I'm David Bateman. I appreciate the opportunity to present to you. I was a hearing officer for many years. And description, I heard just shy of 600 due process hearings as a first-tier hearing officer in Pennsylvania. And as part of that, what I was doing is just working with, I was the one who actually came into the districts and heard things and listened to them and made the decisions. I stopped being a hearing officer because my insurance carrier found out how many hearings I had done, and my insurance went from $360 a year to $18,000 a year. So I now work with school districts when they have been sued to help them move forward. I haven't been involved in a due process hearing since yesterday. And I'm not involved in one until Monday, so I have some time off. Basically, I'm doing some witness prep on that for things like this. But I was involved in 85 due process hearings last year, and I think the number this next year is going to be even higher because it's as you can hear from this case, parent attorneys are coming out of the woodwork, challenging things relating to how we define things. So my promise to you, Mitch will help me solidify this. If you have not been part of a due process hearing, is I know who to contact to get you one, so that you can have one come to your district. We'll have a sign-up sheet that we can pass around. If you would like a due process hearing to come to your district, just let us know. I know who to call. We can get this because we want to spread the joy. All right, so this is part of what we do, but it's a very real part of what you're going to have to live through. And if you haven't been involved in, it's a process I do not recommend. It is completely a process I do not recommend. I am a huge fan of mediation or just anything else as opposed to the adversarial approach that we have as part of due process. There are sometimes it's absolutely necessary, but I'm not an advocate for this. But the reality of the situation is we have to deal with this. So you'll hear me talk more about this in a little bit. All right?
Okay. David is also a professor at Shippensburg University in Pennsylvania.
That's day job. Yeah.
That's his day job.
Yeah.
Just a show of hands, how many of you are teachers? How many are administrators? And do we have any parents here in the role as parents? No. Okay, well, it's good. I guess it's about half-half. So that's interesting enough. As David said, we both really like law. I think we've been referred to as legal nerds. This is my official Supreme Court pen, which certifies that I am a nerd.
Where'd you get that?
At the Supreme Court.
I was with you.
No. So, but at any rate, what we're going to talk about today is the decision in Endrew F. We're going to talk about, I assume probably you're all familiar with it, but we're going to spend a little bit of time reviewing free appropriate public education, Rowley and Endrew, because as teachers and as administrators, our charge is to provide a free appropriate public education or a FAPE to all youngsters with disabilities who are served in special ed. So we're going to start out with a brief review, and we're going to probably go through that pretty quickly. And then we're going to turn to post-Endrew decisions. There have been a lot of decisions after the Endrew case that are now relying on that. And as we'll explain, the Endrew case is very important because that's the new standard by which hearing officers like David and I, judges at the district court or the appellate court, and they have to use the Endrew FAPE standard now. So that's an important thing to understand. So we'll go through some of the post-Endrew case. Like I said, there's been a lot. There's probably only been 5 that I'm going to go through real quickly. One I'm going to spend a fair amount of time on. The others I'm just going to really quickly skip through. And then David's going to come up. He's going to talk about the procedural, substantive, and implementation requirements that we need to follow to make certain that we are providing a FAPE. And then finally we'll get into resources that you can access and leave some time for discussion. So, and if you have any questions or comments, we're going to save 10 minutes at the end, but if you have a question, just please feel free to bring it on up. At any rate, like I said, the primary obligation that we have as special education teachers and administrators is to develop an education, a special education that confers this thing called a free appropriate public education, which is a term directly out of the idea. And essentially what that means is that's our special education related services that we provide to youngsters. The law was, when it was originally passed in 1975, and I was teaching not long after that, and the definition of FAPE was in the original 1975 legislation, which if you've been around long enough, you knew it used to be called the Education for All Handicapped Children Act, or PL 94-142. That definition of FAPE is what has essentially driven the field, because the law told us this is what we have to provide for all youngsters with disabilities. And the definition wasn't real clear. Essentially what it said is FAPE is this. It's a special education and related services that are provided at public expense. So nothing you put in the IEP, parents do not have to pay for that. Must meet the standards of the SEA, State Educational Agency. So if Wisconsin has any additional, Indiana has any additional things you have to do, you have to honor those. For instance, transition. The federal law says transition has to be provided at age 16. But Indiana state law says what? Age 14. What does that mean? You have to follow Indiana state law. Now, on the other hand, the Indiana state law couldn't say, you don't have to do it until you're 18. You have to, at minimum, meet the requirements of the state, of the feds in the FAPE definition. So, some states, that's a real big deal. Like California has a lot of additional, New York has a lot of additional requirements for a FAPE. Indiana, not so much, so you don't have to worry about that. Includes preschool, elementary, or secondary education. And here's the biggie, are provided in conformity with the Individualized Education Program, or the IEP. In essence, the IEP is the blueprint of a child's FAPE. Virtually every case, the Endrew case we're going to talk about, the Rowley case that I'll talk about in a minute, all started at the IEP table. And they all boiled down to what is in that IEP. Now in 1982, and this is when I was teaching, there was a case called Board of Education v. Rowley. There was the first special ed case heard by the Supreme Court, and it involved a young girl, Amy Rowley. Amy was very bright. She was also profoundly deaf. School district provided an IEP for her. However, the parents requested a sign language interpreter. The school did not. On and on and on. It ended up in the United States Supreme Court. And essentially what the Supreme Court did is they had to interpret, what does this FAPE thing mean? It's not real clear. This federal definition wasn't real clear. And so what did the Supreme Court think? Well, they said the way we as special educators confer a free appropriate public education is to ensure that we meet 2 major tests. And this is what is called the Rowley Test, which they used with it in the case of Amy Rowley. The first question that a hearing officer, a judge, is going to ask you with respect to that IEP, or is going to want to determine, is, did you follow the procedural requirements of the law? That's a big deal. Well, in the case of Rowley, the Henry Hudson School District head, so Amy's school district won on that prong. But then they also created a second prong. The second prong was this: is the IEP that you wrote reasonably calculated to enable the child or student to receive educational benefit? So the second part of the test, they said, well, Amy did very well. Unfortunately, probably unfortunately for the Supreme Court having to do this, is she had an IQ of 140. She was not your typical special ed child. So she was passing from grade to grade, doing quite well. So the Supreme Court said, well, the IEP must have been reasonably calculated to provide benefit, because look at how well she's doing. They also said, however, this only applies to Amy. It doesn't apply to every child, but nonetheless, this was the test. So David, every time David had a hearing or I had a hearing about FAPE, about an IEP, that's what we had to do. We had to do that two-part test. The problem is that the United States Circuit Courts of Appeal started having a difficult time interpreting that second part of the test. Well, what is educational benefit? And they started developing all sorts of different standards. For instance, your circuit, the Seventh Circuit, had kind of a lower standard. The Second Circuit in New York, the Fourth Circuit where I am in South Carolina, we all had a lower standard. That the standard was some educational benefit. If your IEP is reasonably calculated to enable a child to receive some benefit, that's A-OK. However, other circuits like David's circuit, the Third Circuit, said no, that is not okay. What the IEP has to do is it has to be reasonably calculated to provide meaningful educational benefit. And so they had a different interpretation. Another circuit, the Sixth Circuit, also developed a higher standard. And the Fifth Circuit sort of had a higher standard. So what happened is we had some circuits that had a low standard and some circuits that had a pretty high standard. Well, what happens whenever that occurs, there's a kind of dispute among the circuits. It makes it more likely that the Supreme Court is going to hear a case. Well, and that happened in the 10th Circuit, which was one of these low standard circuits. And now David's going to come up and he's going to talk about the Endrew decision out of the 10th Circuit.
Let's leave this up for a second. Okay.
Yeah.
Okay. This map's not drawn to scale, obviously, because Alaska's not here. But I also just want to make sure, I do workshops in Guam, which is right here, and it's nowhere near here. So when I'm going there in about 4 weeks, I wish it would be there. We're going to be talking about about this map also. I live in the Third Circuit, which is Pennsylvania, New Jersey, and Delaware. Really small circuit. Look at the size of the Ninth Circuit. Okay, it's based on census data from prior to about the 1900s. So you can see there's been some subtle changes to society since then. Like this term called westward expansion. I think it's a fad, but you can see how this is working. We have firmly placed the statement of lower standard over where the Endrew case occurred, and so I want to talk to you about this. So okay, all right. So the Rowley case is from 1982, and I'll put this again in historical perspective. Is the Public Law 94-142, special ed as you and I know it, started in 1975. We didn't get the regulations until 1977, fully implemented in 1978. The Rowley case was the first case in special education. It was an access law at that point, getting kids in the door. That case involved a child who was deaf, who, if anybody would like the statement of what it was like for her to be a participant in that case, I'll give you my email address and I'll send you what her statement was 25 years after the case. She's now a professor in the California State University system, has a Ph.D. from the University of Wisconsin, and it was a very eloquent statement. That's what I just emailed to you. So, and what you do on a daily basis. So we needed a case to talk about this, since from 1982, we had been living with what was referred to the two-part standard from Rowley, which, and you can see how it was very differently defined. The other facts about the Rowley case is involved a child who's deaf, who had an IQ around the 140s, depending on which test you had, which is not, I'm going to put it out there, is not typical of what you're seeing in special education. But for many of you, that's what we heard about, and we talked about defining appropriate education was using that as our standard. Okay? I know it's an IQ similar to many of you, so I'm aware of this, but for most of the students you work with, maybe not so much. But we had a case that was percolating out of, and you can see back here from the map, from just south of Denver. The Douglas County School District, if you go down I-25, it's just south of Denver. It's the first district just immediately south of Denver. And so I was actually recently there. I was there 2 weeks ago. Was it 2 weeks ago? I think I said any of this. 2 weeks ago. This is actually the school that little Drew went to. And there's snow on the ground. It's, again, you can't quite see it, but you can see the around the edge. You can see the big buildings of Denver. So it's that kind of proximity. Okay? He was attending the school from kindergarten through 4th grade. Kid with autism, ADHD, and some significant behavior problems. And his behavior problems were escalating. Despite this, there was nothing in his IEP that was addressing his behavior goals or anything relating to his behavior needs. Additionally, there was no regular progress monitoring data for him. Okay, so we talked about behaviors. What were some of the behaviors he was doing? He had a problem with flies. If a fly came into the classroom, he would just elope from the classroom. He'd just go, things like this. He was constantly failing bus. He had problems with ponytails. When he would get severely frustrated, he would stand up and urinate in the middle of the floor. And so we're not going to demonstrate for you, but that's one of the things that he would do. And this posed a problem, and as he was getting bigger, his behavior problems were escalating. And so the parents, despite this, he was not making progress because he also had the same goals on his IEPs every single year. Think about how much time this would save you if you were to have the same goals each year for a kid. Just think about this. They were also not reporting to the parents on a regular update about how he was doing on his goals. So the parents, unhappy with the progress, enrolled in what's called the Firefly Autism School, which is in southern Denver. And these two pictures, I was there in August. You can see it's green there. 2 weeks ago, it's snow on the ground. And I'm not trying to talk about one is where everything's green and one's different. It's just there's two happen to be 2 different times when I was there. Things like this. I'm in Colorado a lot. But you can see this. But the parents enrolled him at this school and then sent the tuition bill back to the parent, to the district. And the district said, no, we're not going to pay this tuition bill because we felt like what we were doing was appropriate. And we thought what we were doing was necessary. So you can see this, right? So the parents appealed to, they filed basically a hearing claim, and in Colorado they use administrative law judges, and the administrative law judge ruled for the district. The district was doing just fine, not a problem, and things like this. Parents filed in the Circuit Court of Colorado. The Circuit Court of Colorado said the district's doing just fine. The parents then filed to the 10th Circuit. Back to our 10th Circuit map. 10th Circuit map, they filed to the 10th Circuit here, and the 10th Circuit said the district's doing just fine. I work with school districts all the time. If I've got a hearing officer's decision, a circuit court decision, and a 10th Circuit or circuit court decision like that, I'm going to think that my poop don't stink, and I'm going to be pretty happy. I'm not going to make any changes. Parents then appealed that case to the Supreme Court, and so that's what we heard on the Supreme Court. And you can see this, okay? The 10th Circuit decision. So we'll come back to this in a minute, but it's things like this. They appealed to the Supreme Court. The question presented, what is the level of benefit school districts must confer on children with disabilities to provide them a free, appropriate public education guaranteed by the IDEA? And you can see how very different it was being applied. And again, I live in the 3rd Circuit, which has historically had a high standard, which really bothers me about the rest of the states, things like this. And actually how this is emphasized to us is I live in Carlisle, Pennsylvania, which is home of the U.S. Army War College. And we get a lot of colonels from other colonel wannabes who move here from other states, and if they have a child with a disability, a spouse stays with their child with a disability in our school district while the other one is posted to Iraq, Afghanistan, or the Pentagon, because they feel like this is the first time that they've actually had good services. And it's really kind of sad how this works. But this is what the parents appealed to the Supreme Court. And so you have to think about this. And then they heard oral arguments on this on January 11th, 2017. Mitch and I were both there for the oral arguments. It was cold. And if you ever, and I put this out there, if you ever get a chance to go see oral arguments on whatever it is, I highly recommend it. I highly recommend it because it'll give you faith in 1/3 of our government because they're so prepped. They really are. They're well prepared to understand what's going on. The problem is, in order to get in, you have to be in line. We were in line, like you were in line like
4:45.
4:45. I was there. I was late. I was at 5:05 in the morning. It was dark. It was cold. It was kind of rainy. I'm still pissed. But it's interesting about this. But and they don't let you in until about 9. So you're out there the whole time. And yeah, it was ugly. Things like this. This case was heard when there were only 8 justices. They had not appointed a replacement to Antonin Scalia at that point. So there were only 8 justices. What's interesting about this, all right, so the Supreme Court issued its ruling. And when I'm going to go back real fast. The 10th Circuit case here, okay, one of the authors of the case of the 10th Circuit that said the district was just doing fine with this really low standard was a man by the name of Neil Gorsuch. Maybe you've heard of him, all right, okay? He was the one who was replaced to be the 9th justice to replace Antonin Scalia. And he was questioned actually pretty intently as a part of his confirmation hearings by then Senator Al Franken from Minnesota. So it's names you all have heard, whether you've watched comedy or not, but you can see this, how Supreme Court justices do pay attention to these things like this. The Supreme Court issued its ruling, and I'm going to give you a visual reference on this. The district had been basically defending a low standard because they kept winning. They kept winning, so they're going to give a low standard. As a consultant to districts, I would say if you keep winning, don't change. So they were going for this really low standard. The parents were asking for a really high standard. This is my visual reference. In effect, the parents were asking for every kid to make a year's worth of progress every single year. And I don't want to rain on anyone's parade, but there are some kids, because of the severity of their disabilities, they're not going to make a year's worth of progress. Okay? The best example I can give to you is my brother-in-law has profound intellectual disabilities. 62 years of age, he needs help. He's nonverbal, he needs help toileting, he needs help getting dressed. He knows maybe 10 signs, of which 8 relate to going to McDonald's right now. And so, we could spend a lot of time with him. He's not going to make a year's worth of progress. And what's interesting about this is when I say that the justices are well prepped, the line of questioning from Chief Justice Roberts, who's increasingly gained fame just in the past week and a half, he's been on TV a lot, is he was kept asking, we were sitting next to each other, we kept asking about this. It was, what about the kid's unique circumstances? And which really does pay attention to this, and I appreciate how he's doing this, okay? So with the Supreme Court ruling, come back to this, okay? To meet its substantive obligations under the IDEA, school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances, all right? So that's what we're talking about, and we're emphasizing it as a part of this, okay? So that's what we did, okay? But they vacated their decision from the 10th Circuit and sent it back down to the 10th Circuit to here because when we talk, remember, Endrew is basically a tuition reimbursement case. And a tuition reimbursement case is a 2-part test. First, is the district doing what it's supposed to be doing? And the district in all those cases lower, the district was doing just fine. If the district's doing just fine, you don't go to the second part, which the second part is, can the private school actually do what they're supposed to be doing? It's a much lower standard than we have for the first standard. And like that. We have a lot of 2-part tests in special education. So, but it was an important part of this, okay? The emphasis here, and we've highlighted some words here that we really want to stand out. Maybe you can figure out what these words are from your distance, things like this, but we've highlighted some things. IEP must be able the child to first make progress. Emphasize, make progress, okay? Previously, it was benefit. Now we expect the kids to make progress, okay? So, in progress. So we'll come back more what we mean by this, but things like this, okay? The essential function of the IEP is academic and functional advancement. It's not just academic advancement. It's also functional advancement. Because when you think about this, Drew's IEP had academic goals. He had behavior issues that needed to be addressed. And we need to talk about the independence relating to this and making sure that people, and that all students get these as reasonable opportunities, and we address these kinds of things like this. So this is a very important part of what we're talking about, and this is something we need to emphasize as a part of this. So it may not seem like a big deal to you, but you'll hear later it's a big deal. The switch from benefit to progress is huge, okay? And the example I can give to you is years ago when I was younger and had a lot more energy, I used to run ultra marathons. And there was one day I did like a 6-hour training run. You have to do this in order to get ready. And it's like this. I came back, I was dehydrated, and there was a water main break in front of my house. There was no water running to my house. I'm dehydrated. I'm hangry. Doesn't even come close to describing my behavior at that point. Okay? But I had this much water in a cold glass in the fridge. Okay? This much water. I drank the whole thing. Did I benefit? Maybe a little bit. Did it make progress? No. No, I needed gallons. And so it was really interesting. But many states, this is what the benefit that some of these kids were getting. They were getting a very low benefit. And this has been consistent. When I was a teacher in Virginia in the 90s, I remember my principal saying to me, I don't care what you do down there, just keep the students quiet. And then she truly meant it. She didn't want to deal with what I was dealing with and any behavior problems, so we have to talk about this. So when Mitch talked about the Rowley Test earlier, we've now emphasized that it's now the Rowley-Endrew Test. It's a 2-part test. The first part has stayed the same. Okay? Has the state complied with the procedures of the Act? And has the state complied with where we are with this? And things like this. This is why your special ed directors hound you for timelines. This is why special ed directors hound you to make sure you have the right people in the room. First, it's written into the rules, but it's been codified twice now in Rowley and Endrew. So this is a standard thing. The second part is a harder get. Is the IEP reasonably calculated to enable a child to make progress appropriate in light of his or her circumstances? Emphasis on progress. Okay? You can see how there's subtle switch on this. We'll talk about this. Okay? So talk about these things and address these, all right? So moving on to the final chapter, okay? Right, the final chapter of this is the Supreme Court sent this back down for the lower courts to hear this. And you see how they went back down, things like this, okay? They went all the way down several levels, and remember, this kid was going to a private placement that in the end was costing close to $70,000 a year. And now he's, I think, 17, 18 years of age now. He's much older. He started this when he was in 5th grade. That's years of these services and attorney's fees. You can see $1.3 million settlement to pay all this. Okay? The Firefly Autism House, which I parked in their parking lot when I took that picture in August, is not a very big building, but it serves solely individuals with autism. And it's easy access, only about 20 minutes from where Drew lives, so it's easy access kinds of things like this. Traffic in Denver can be bad, but it's an easy thing for him to get. So we have to live with these things. Okay? Mitch is going to now talk about some of the post-Endrew cases and bring you up to speed about, now that we've done this, yes, this is 3 years ago, but we're now living with this. What are some of the effects of this? And then we'll bring up some resources on this in a little bit. Okay?
Okay, well, like I said, there's been a lot of cases from federal district courts, United States Courts of Appeals on FAPE. Most of them have not been that important yet, and I'll explain why I believe that's the case. But here's a few. The Ninth Circuit had an important case called MCV Antelope Union High School District. Back a few months after the Endrew decision, and this is a really important decision. Now, the reason circuit court decisions are so important is because if we think back to those maps, how you are in the 7th Circuit and you have Michigan, Indiana, Michigan, Illinois, because when the circuit says something, that applies to everyone in those states. So you have to follow those. This was heard out of the Ninth Circuit. That's that huge circuit out west. Then another case was heard out of the 5th Circuit. That's the Texas area, Dallas Independent School District. v. Woody. There was one in the Second Circuit, which is New York. In the New York area, Mr. P v. West Hartford Board of Education. One heard in David Circuit, KDV by Dunn v. Downingtown Area School District. And another one in the Fifth Circuit, ERV Spring Branch Independent School District. Now, we're not going to spend a lot of time talking about these cases, with the exception of that. I'm going to spend a little more time on that. But we're going to just go through these quickly and just let you know how they've kind of interpreted what the Andrew Standard means for us. Now, no circuit, with the exception of the 10th Circuit, has actually said Andrew overturns our previous low standard. That's because there haven't really been any cases in those circuits. Except in the 10th Circuit, there still hasn't been a circuit court decision. It did go to the district court, and the judge there, Judge Lewis Babcock, did overturn his previous decision. So that merely more than de minimis, the district court has now said that is not an appropriate standard under Endrew. Okay, now, first one I want to spend a little time on, and now I have a few extra slides just because I put the names by themselves, and I split a few up, but they're essentially everything in the handout. And by the way, our emails are on the first slide, so if you want any of this information, email us. We can send it to you. Anyway, the MCV Antelope Valley High School Union School District involved a young boy, just called MC by the court. He had a genetic abnormality that resulted in him being blind and being developmentally disabled. Well, what happened in this case is the school district got together with the parents, the mother in this case, developed an IEP for MC. The mother signed the IEP, but she said that I don't agree with the IEP. I mean, I'll sign it because I want you to deliver the services, but I don't believe this IEP actually confers a free, appropriate public education. So what she did is, after she signed the IEP, she filed a due process in the district. An ALJ, administrative law judge, heard the particular case, and he decided in favor of the school district, saying that, in essence, the school district had developed an IEP that did confer a FAPE. The parent then appealed to the district court, who affirmed the lower court, saying the school district, Antelope Valley, had implemented an IEP that did confer FAPE. Well, there was a couple of interesting things about this IEP. One of the problems with the IEP is it listed assistive technology services, but it didn't say what those services would be. What they were going to be providing was not listed in the IEP. It just said assistive technology services. Another problem is that the goals were not particularly measurable. Some of them were, some of them weren't. And also, the IEP was not specific in terms of the services it would offer. Like I said, it just said assistive technology. Some of the services did not have the frequency, the location of the services, the duration, which are all required by the federal law. Well, what happened is the mother then appealed to the United States Courts of Appeals for the Ninth Circuit. And they said some very interesting things that I think have, even though it's in the Ninth Circuit, we should really pay attention to. One of the things they said is, of course, we all know, the primary purpose of the idea is to ensure FAPE to youngsters with disabilities. And when we formulate an IEP, we have to comply with the procedural and the substantive elements within the idea. In other words, we have to meet both parts of the Rowley Test. Our school districts need to meet the procedures of the law. They also need to write an IEP that's reasonably calculated to enable the child to make progress in light of the child's circumstances. Now, another thing the court said is that they review in an IEP case unlike other agency reviews, can be conducted what is called de novo, or de novo. That means that the court can literally decide to start from the beginning and re-rule again. Now that's not always the case. In a lot of administrative agencies, a court's task is just to say, well, the administrative agency found this out and we're going to rule on that. And they kind of take those facts as true. Well, that doesn't always happen in special education. That didn't happen in this case. As the judges said, we can accord some deference to the administrative law judge's findings, but only when they are thorough and careful. Well, the judge, the Ninth Circuit Court, looked at the administrative law judge's decision, and they said, this is not a very good decision. This is not careful, it's not thorough. The administrative law judge overlooked some things. And so, like for instance, one of the contentions of the mother is that the school district had failed to follow all the procedures of the idea, and they listed that as the complaint. Well, one of the things we do as hearing officers is we have 45 days to write a decision. Well, in this decision, the administrative law judge had failed to put down that the mother also had procedural concerns about what the school district did. And that's a fairly big error. So they said this person is not very careful, so we're going to look at this decision again on a de novo basis. And what they did is similar to what the Supreme Court did. They looked at the decisions prior to that and they essentially said, you got it wrong. This is the way you need to rule, and we're going to remand it. And here's some of the things that the Circuit Court said. In enacting IDEA, I should have said, Congress was as concerned with parental participation in the enforcement of the idea, of the IEP, as it was in the formation. So what had happened in the school district, one of the things I had said is the school district had failed to be specific about the services they were implementing. For instance, they didn't say what assistive technology was offered. They didn't say, in many cases, how often the services would be offered. Well, the Circuit Court said those are pretty big errors, because the purpose of the IEP is not only to have the parent there to write the IEP, but the purpose of the IEP is also to have the parent be able to monitor what is occurring in the child's education. And if the IEP is written in such a way that the parent cannot determine what was actually decided on, that could be a very significant error. And so, again, the Circuit Court said parental participation doesn't end when the parent signs the IEP. Parents must be able to use the IEP to monitor and enforce the services. So what that tells us is that when we list the services in the IEP, we have to be very specific about it. We have to list what those services are, and we have to list how often they're provided, will a child receive it 1 day a week, or 1 hour a day, or 1 day a week, or whatever. We have to be very specific about that, because that issue in itself, the MC Court said, was a real procedural error. Now, so that's one of the things. Now, another thing they said, which is very interesting, is the IEP, like a contract, embodies a binding commitment and provides notice to both parties as to what services will be provided to the student. Now, the IEP is not a contract in that it does not guarantee that a child is going to meet the goals. But what it does guarantee is we're going to make good faith efforts to provide all those services we said we'd provide, and in that sense it is like a contract. The Circuit Court said Basically, they violated the contract. They didn't provide the services they said they would. In fact, the school district had provided, I think it was 200 minutes they had put down in the assistive technology that they'd provide X amount of services in a week's time. And they didn't say what those services were, but they realized they made a mistake because they meant a month. So what they did is they went back and they changed the IEP, but they didn't contact the parent. They unilaterally changed the IEP without any notification to the parents at all. That's a big procedural error. So thus, like a contract, it is a binding commitment that we're going to say that we're going to meet those, we're going to deliver those services that we said we'd deliver. A few other interesting things. Again, and I mentioned this already, the court said when a parent is unaware of the services that are going to be provided to their child because we're not clear enough in the IEP, even if it's been accepted by the parent, if it is not clear enough, that means we have a real problem. Why? Because parents cannot monitor how these services are provided. That means the FAPE has been denied according to MC. So again, the message, we need to be really specific in our IEPs when we develop those services. And this is also very interesting. One of the things we know from a Supreme Court decision many years ago is the party that challenges the school's IEP bears the burden of proof. That is, so if a parent challenges FAPE, say the IEP did not provide a FAPE, that means that they have the burden of proof of proving that the school district did not provide FAPE. But according to the Ninth Circuit, that cannot be the case when the IEP is inappropriate. When the IEP is such as the MC's IEP was, did not list services, in such circumstances, according to the MC court, the burden of proof shifts to the school district to show that the services a student received were substantively reasonable. Thus, again, we have to be very specific about those services that we're providing. If the parent signs the IEP, that doesn't let the school district off the hook. If we have not been specific enough, that can shift the burden of proof to us, according to the Ninth Circuit. So that was a very important decision. Now, what they didn't do is say that this overturns our previous standard, because if you remember back, this circuit had kind of a confused standard. Some parts of the circuit, some panels of the circuit were saying meaningful, some were saying lower. So it really didn't do that. What they said, what the Ninth Circuit said in this case, though, is now this decision has to go back to the district court. They have to re-rule, understanding that they were reversed, that the IEP is not appropriate because they had procedural errors, it was not specific enough, and they also have to look at it in terms of the Endrew standard. So this will be a real interesting case to look at when the district court finally decides it again, which they have not, but clearly what they're going to do is they're going to overturn their previous ruling. So that's an important decision. Another important decision that has come out of the New York area is this, and I'm not going to really spend a lot of time on this particular decision, but what happened in this case is the school had made a number of kind of minor errors, procedural errors, and the parents brought a due process hearing officer, hearing decision saying all these the school district had committed all these procedural errors. Well, the idea in 2004 said unless procedural errors amount to a denial of FAPE, they're not good, we don't want to do them, but if they don't amount to a denial of FAPE, a procedural error does not necessarily mean the school district will lose. Because some procedural errors are not that big a deal. Well, in this case, the school had committed a lot of little procedural errors, And what the court said, what the Second Circuit Court said, is they had done so many errors that those multiple errors in and of themselves resulted in the denial of a FAPE. So it's very important that we understand those procedural errors and or those procedural requirements, and we follow them. Also, the court did say prior decisions of this court are consistent with the Supreme Court's decision in Endrew F, which is kind of odd because a lot of the Solicitor General didn't think it was a high standard, but they said it was. Now, the Circuit Court, or the KD case out of David's Circuit, was an interesting case because some of the annual goals were repeated. And as what happened, as David described, is so many of Endrew's goals had been repeated, that in itself was considered to be a substantive error. Well, in this case, there were some goals repeated. And what happened is, because of this, the parent decided to go to a due process hearing. Hearing officer took a look at the ALJ examined the case, and he said, yeah, some of the goals were repeated, but most of the goals were not. Most of the goals were new. The services were changed, and this is the most important part. They had data that showed the child was actually making real substantial progress. So what the court said is, again, a student's IEP must aim for progress that is appropriate given each student's unique capabilities. That was kind of their way of saying reasonably calculated to enable the child to receive, to make progress in light of his or her circumstances. They said unique makeup. And then they ruled in favor of the school district, saying, well, the school district did have data that showed progress. They did change a lot of the goals. They kept some of the goals, but although a repetition of a student's annual goals from one IEP to the next is not ideal, it doesn't necessarily prove that the district denied the student FAPE because she showed improvement in her baseline performance. In other words, they had data that showed the student was making progress. So despite the fact that some of the goals were repeated, that was not a huge issue because she was making progress. The Endrew decision, by the way, did not overrule the Third Circuit's meaningful educational benefit standard. Well, as we showed you and David explained, that's always been a higher standard in the Third Circuit. So the Third Circuit just said again, we always had that high standard. It's not overturned. Now, I think this is the last one I was going to talk about real quickly. Is a case called ERV Spring Bench Independent School. Now, this is in the Texas area, the Fifth Circuit, and it was actually a pretty complicated case. But I think in the final analysis, the most important part was this circuit court did compare the new Endrew decision to their old decision. And what they said is the Endrew standard provides more clarity, but did not overrule the Fifth Circuit's existing four-step standard announced in a decision way back in 1997 called Cypress Independent School District. And what that required is this, that an IEP, this was the Fifth Circuit decision, way back in 1997, an IEP reasonably calculated to provide FAPE must be individualized based on the student's assessment and performance, administered in the least restrictive environment, implemented in a collaborative and coordinated collaborative manner with the student's parents, and allow a student to gain positive academic and non-academic benefits. So the Fifth Circuit said, this Endrew does really not overturn our decision. Now, so that's some of the case law that's been heard since Endrew. And it's told us some interesting new things, but it really hasn't had a great impact, and thus far only one circuit had said, this overturns our old standard. Most circuits have not really ruled on that yet. Well, except the Third Circuit and the Fifth Circuit, which kind of had a higher standard anyway. Now, the important thing I think about this is that case law is really not the best way to determine what the effects of the Endrew decision are. And one reason is because of the importance of deference. Courts tend to defer a lot to lower courts. For instance, and I mentioned in the MC case, the hearing officer, in that case the administrative law judge, had made a pretty bad decision. Was not a good decision at all. And the court said, we're not going to defer to that decision because it was not thoughtful, it was not careful. But a lot of courts do defer to lower court decisions. So that can be kind of a problem because, as David can probably attest, and I can, when in South Carolina we used to have to go through training to be a due process hearing. Every year we'd have training, and I often would sit in this room of people, probably as many as we have here, and think, my goodness, I hope some of these people never make it as a due process hearing officer because they just didn't understand the idea. And so, unfortunately, those things do happen, and courts tend to pay a lot of attention to that, not always. Now, another thing, and David will talk about this, is advocacy groups are arming parents and advocates in the specific requirements of the Endrew decision. So we're in South Carolina actually seeing more due process hearings, people coming into meetings, IEP meetings and hearings, whose advocates or attorneys who are advocating for them are very schooled in what this new decision says. And that's making a huge difference. Another area that we have to consider to be a real effect of Endrew that maybe is not as evident is that in many ways this decision flips the burden of proof from parents to school districts. Because remember, one of the things that the Supreme Court said in a decision a number of years ago is that if parents challenge a Supreme Court decision, or a school district's IEP, they bear the burden of proof. Well, Endrew had a sentence in it saying that kind of turned that on its head, because what it said is hearing officers and judges can expect that school district officials will give a cogent and responsive explanation when asked, is this IEP reasonably calculated to provide educational benefit? What that means is if your school district is in a hearing, or if you as a teacher are having to testify in a hearing, the hearing officer may turn to you and say, I want you to tell me why did your IEP enable little Johnny to make educational benefit? That's on you. That's on us as special educators. So that really kind of flips the burden of proof to us. That's one of the reasons I think it's so important to think back of the case I was talking about earlier, where they had data to show that the child had made progress. We need to have data because it's very likely under this standard we're going to be asked, how do you know you're making progress? Now, the last thing is, the question is, will school district attorneys settle more quickly if you as school districts do not have data to show proof that a child has made gains or that the IEP was reasonably calculated to enable the child to make progress? Now, one thing I can say about that, and David will talk a little more about that, but an acquaintance of David, Mayfund is it? Mayfund. Kathleen Mayfund, she's an attorney with I believe they're out of Pennsylvania, right? Reed Smith? Richmond, Virginia. Reed Smith, consultant to LRP, said at a conference I was at, 2015, made this statement. I went up to her and I said, I would like to quote you. Can I do that? And she said, please feel free. They just represent school districts. And what she said is that when I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me information on your student's progress. If the teacher doesn't have data, I advise the school district to settle. So it's very important that we have data, that we collect data right from the beginning. And if we think back of MC, remember it said the IEP is important, not only because the parents involved in the formation, but they're also involved in the enforcement of the IEP. So they can expect that we're going to be collecting real data, and that data needs to show progress. So now, David is going to come up now and talk about the 3 areas of FAPE requirements.
And I'm going to piggyback on what he just said about looking at case law as a way of actually justifying whether Endrew's made an impact on what we were talking about. Is, as I said earlier, I was involved in 85 due process hearings last year. 79 of them we settled because the teachers, we had no data. And so I want to talk more about the procedure and substantive requirements relating to that, because if you do not have data, and I do witness prep. In fact, that's what my early morning call tomorrow morning is a witness prep for a teacher. And I don't think she has any data. I'm not going to put her on the stand. It just doesn't make any sense, because first we're going to lose, and then second, it's a waste of everyone's time. Question. Well, let me tell you, is do the right thing. Okay, I defend districts all the time who are doing the right thing. I'm not a problem with that. But you have to take data on the goals and objectives of the child, and it has to be regular data. I'm working with a district right now that only takes data once per marking period. So I asked them to graph that. They drew the XY axis and they put a point here, and I said, can you tell me if that's going up or down? They said, no, it's right here. And so they can't. That, yes. So take regular, frequent data on this. So we actually have some handouts we're going to give to you, and some resources that came from, we did some work for the U.S. Department of Education that will help with us about things like this. I have no problem often preparing speech pathologists for testifying, because as per their ASHA requirements, they take data out the wazoo, and from other places too, but they take all sorts of data. What is tripping up districts is that they don't take data on goals. They don't take regular data on goals, and they don't take behavior data. We have academic data like crazy. We need to train paraprofessionals or teachers how to take regular behavior data. I'm skipping ahead, but to answer your very, very nice question. No, it's a great question, and I sincerely appreciate you asking and appreciate the frustration that you're expressing. But we need to take paraprofessionals on just taking regular frequency, duration, or latency, or interval data on something like this, and view it as snapshots. And when we talk about data, you think we have to have a paraprofessional observe this child for like 3 weeks solid? No. Give me a half-hour view here at like 9 to 9:30. Observe this child and a few other kids in the classroom. Give a sense of how off task this kid is every morning from 9 to 9:30. Teachers teaching so that we're getting some behavior data. Because this is actually what trips up districts. It's not so much the academic data, it's the lack of behavior data. So training there. So I train paraprofessionals all the time to take behavior data. And take also anecdotal data. Like, give you an example, I trained a paraprofessional about a year ago, and I was basically frequency count on how many times a kid actually did something. And what he did, it was a 45-minute observation. She was on one side of the room, I was on the other. And he got up out of his seat and things like this. And so she got up out of his seat once. All right? So she comes over, I got my data, 1. Right? He was out of his seat for 42 of the 45 minutes. Wandering around the classroom. So it's not just the tick of what happened there, but also the anecdotal description of what's going on. But the teachers are frustrated because they can't get this. So maybe it isn't a dedicated paraprofessional in the classroom. It's someone who comes in and does a regular observation, and we can compare apples to apples. But also comparing how this child is compared to others in the classroom. Because I'm working with a district right now, and I pissed off this teacher, where the kid, which I do all the time, is that the kid, what he did, he was sharpening his pencil 39 times in a 2-hour period. And I said, wow, that sounds like a lot. She said that, well, what should we do? I said, how's that compared to other kids? I don't know. Give me some data how this compares to another kid. So the next day it was 33 times, and this other kid did twice, so I viewed him as an outlier. So we decided to address these kinds of things. But you need to give me some data about how this kid is compared to others as a part of this. So it's not just that one kid. And that's what often trips up this, is because I was in a district, it was in November, where the kid was on task 55% of the time. Sounds terrible. Everyone else in the class, we found out, was on task between 50 and 60% of the time. He's just the one who just kept getting caught. So we have to think about these things. So behavior data, academic data that is taken regularly. But then we'll talk about this in a minute, is then use that data for informed decisions. There's an acronym that we have in special education. Many of you may not have heard this acronym. We have a lot of acronyms. This is actually a real acronym. I make up stuff all the time because I teach the undergrad intro to special ed class. And I just make up stuff just to see if the students are paying attention. I told them the other day that the bumps on the freeway are for the blind drivers. And so I told them to write that down. And they said, that's not true. I said, yeah, that's why I have Braille and drive-up ATM machines. So they believe me. But what's interesting about this is this is a real live acronym. And it truly, this is what you need to think about when you go back to your team about this. The acronym is KOSHK. KOSHK. Okay? And it stands for knew, as in K-N-E-W, knew or should have known. Knew or should have known. Okay? You have a kid who you determine at the end of the first marking period is not making progress, is not meeting their goals. Okay? And you do nothing, I'm not going to defend you. All right? You knew or should have known child was not making progress. Something needed to be altered at that point. I don't care if it's changing the grouping, changing the instruction, changing the intensity, changing where the child sits. I don't care. You do something and then you document the snot out of that. All right? And if that doesn't work, you do something else. And if that doesn't work, you do something else. All right? That's defensible and that's better for the child. As opposed to having a child sit there at the end of the first marking period not make progress, and the second marking period not make progress, and the third marking period not make progress. And we do nothing? Who's the slow learner in this situation? And we need to think about these kinds of things and make these determinations. So what I go around is I spend a lot of time training principals and administrators is monitoring what's going on at the end of each marking period. You see what's going on at the end of the marking period, use that as a red flag that's being waved in your face. Kids don't raise their hand and say, excuse me, I'm having great difficulty with the math assignment. Please give me additional assistance. What they do is they throw, kick, scream, yell, or turn in bad papers. Use these as red flags. By using these red flags, you then can do a better job of providing services for these kids who can't articulate what they actually need. So when we talk about these things, we need to think about using these and stopping kids from suffering. And so using that data to then make informed decisions, because these kids do not choose to have a disability. It's not like they wake up and say, I think I'm going to have LD today. Next week I'll have autism because they have cooler bumper stickers. No, they don't do these things. They have to think about what can we do to provide supports for them. Okay? So that's where we get to. I'll be happy to talk more about this with you later after this. All right? Get to this. Procedural requirements. Okay? Remember the two-part test from the Rowley Endrew standard? The first one was on the process. The first part was the process. Okay? Make sure the parents understand what's going on. Second, talk about the how and the when. Again, the timelines, the crossing of the T's, dotting the I's. Okay? But have you followed the procedures? And this is a direct quote from the Rowley decision from 1982, a year that some of you don't remember very well, but was a good year. All right? Okay? Those of you who don't remember 1982, just keep your hands down. It just pisses me off. Okay? So about this, okay? But I talk about this. This has been the law since then. The second part was the substantive requirements. The substantive requirements, right? And talking about these kinds of things and making sure that the kid is making progress. This is the what. This is the what. And this is what has been changed. This is what has been changed. So talking about what Mitch very articulately stated earlier, using case laws of what's going on about this, is there are so many parent attorneys who have come into the area of special education law who don't really quite understand special ed law, and so things like this. They don't understand the difference between LRE and ESY. So I have fun when I talk to them about these things. But I talk about this is what we need to think about is understanding is that there are attorneys who will call districts and say, we'll settle this case not to go to due process. We won't file a due process if you settle for this amount of money here as a comp ed claim. Okay? Back to the knew or should have known clause, things like this. And it's interesting, I did a study of this. We did analysis. I was in Western Pennsylvania not too long ago. We'll settle for $8,000. $8,000 and some reasonable attorney's fees, things like this. Okay? To fight the case, to put on a defense, to bring in the witnesses, to pay for the attorneys, to do the witness prep, things like this, cost close to $15,000 to $17,000. Take that to a school board. We fight for $17,000, which could be a slam dunk or not a slam dunk, or we settle for $8,000. Okay? School boards don't often understand this. Okay? So actually, I'm starting a book for CEC starting in the next month or two, what school boards need to know about special education. It's school board members who are having to make these decisions. The joke is the book's going to be in large print with a lot of pictures. But it's interesting about this is you have to think about this is we need to talk about the fact that there are individuals who are getting into this field and trying to push this envelope, which brings us to the implementation. You need to make sure that you're implementing what's going on and you're implementing these things. Too often we spend an enormous amount of time writing these grand, glorious IEPs and then we sit them on the shelf not to review them for another 350 days. You have to think about them as living, breathing documents. Documents that you can benefit from, that the kid benefits from, that we've worked together as a team. And if it's not working, because most of us, before we had a lot of emergency certified, when people used to go through their, 10 years ago, when you would go through your training program to be a special education teacher, the last class was on how to predict the future. You remember this? It was the class was just predict the future and things like this, so that you could write a goal for a kid and what the kid was going to be doing a year from now. It doesn't work with lottery scores. I've tried. But interesting about this is things happen to kids. Kids sometimes make more progress or make less progress, or a kid gets sick, or kids move in and out, and things like this. I mean, things that you're all aware of, but you have to think about these as constantly changing documents as opposed to a stagnant one-time kind of thing. And that is something I can't emphasize enough. Too often we write these things and then we don't do anything about them. Use them as a document that needs to be modified. Not necessarily the whole shebang, but maybe that part. That part needs to be addressed and addressed like this. So what we have for you is we have resources. And some of you have been emailing me as a part of this presentation saying you can't get access to this. Are you able to, you're not able to get this? Some of you are, some of you are not. All right? I'll give you my email address at the end. We'll get you these things so that you can get access to these things like this. The first resource, and this is a free resource, which I'm pushing out like crazy to everyone. In fact, we have handouts on this. All right? This is an IRIS, what's called an IRIS module. Okay? The U.S. Department of Education, when they realized that something needed to be done relating to the Endrew Supreme Court case, that we needed to train school districts and administrators relating to legally proficient IEPs, they said we need to do something better. So the U.S. Department of Education sought Mitch and me out on this, and then we put together, this is the splash page as we speak, right now. You can see this. Go back. I like the other one better.
It doesn't go back.
It doesn't go back? All right, okay. All right, don't pay attention to what's behind me. Pay attention to me, all right, because it's all about me. As what we have for you, first, the IRIS Center has a variety of modules relating to special education. Every single thing at this website is free, as in F-R-E-E. I want to emphasize this. No cost to your district kinds of things. But what they have now is we have a training module, and you can see that first, this is the one here, what IEP team members need to know about legally proficient IEPs. It's about a 2.5 to 3 hour long module that you walk through with there's a test, and you can print off a certificate at the end that has the U.S. Department of Education's stamp of approval that this is what you need to know about legally proficient IEPs. The author standing over here was, right there, that's him, okay? But it's what's really interesting is I go around to school districts and people have been using this module and they say, do you know Mitch Yell? Yeah, I do. Yeah. And so, yeah. He lets me talk to him periodically. So it's interesting about this. So we also did a parallel module which for what administrators need to know about special ed and leading IEP team meetings. It's a parallel module written for principals and for special ed administrators. I wrote that one. And what's interesting about this is I've done a lot of writing. What's interesting about this is it went through, I think, 7 layers of lawyers' approval at the U.S. Department of Education in order to get the official stamp of approval that this is something that they could put out. And I've heard some statistics right now that it's being used by 35 state departments of education for teachers to learn about IEP development. So, and it's only been out a few months. And Mitch and I presented pretty nicely with these individuals. But you can see this is the one. But this is the one for administrators. And this is when you go to that website, this is the splash, you'll see that's the one that's on the splash page. I wrote the one for administrators, and they were written in conjunction with the others, similar outlines, trying to present similar format, kinds of things like this. But it has the U.S. Department stamp of approval, and it's free. Please push this out to your administrators. We get no royalties from this. But we're trying to get it out to as many people as possible, because it really is, yes, there are some, it covers probably 98.9% of what you need to do in Indiana. There's that little tweaks that you guys have, but if you get that, I'm going to say you're golden. But it really is. It goes into great detail, and it emphasizes a lot what's going on as a part of this. And it's a wonderful resource for you to use. So this is what we want to address and talk about this. The high quality IEPs, developing high quality IEPs, things like this. It's got great information. We've done a lot of different writing projects together over the years. This was an intense one. Just the layers of reviews and the way they would change one word here, and why did they change? And if you change it back, they would slap you, kinds of things. But it was intense. But I really want to push this out for you. The next resource we have, right, is the National Center on Intensive Intervention. If you need to provide interventions to kids with disabilities, this has a list of interventions and resources for you that I really do highly recommend as a part of this. And it has wonderful resources for you. And it has opportunities for you to include and to look for interventions for kids. And so the National Center on Intensive Intervention talks about, it's at the American Institutes of Research, which is based in DC, but they have locations across the nation now. But it talks about how to set up progress monitoring, how to monitor, where to pay attention to these kinds of things. So it really does have some great resources for you. Their stuff on there is also free, which is the watchword for the next few minutes. If you would like us to sell things, we can sell you stuff. Don't worry, we have things if you want. In fact, type one of our names to the Amazon. Either one, I don't care. Type, and there's books you can buy. And my understanding is Amazon will only let you buy 300 at a time. What I want you to see is if you guys can push this and buy 500, 600. Some of the books that we put together, they make really good gifts at Halloween. When kids in your neighborhood are trick-or-treating, pass them out some of these legal books. It works out really well. Your neighbors will remember these things, and it'll be a memorable. It's good for society as a whole. So okay, yep.
That's another page.
High quality strategies for setting high quality goals, things like this, as part of the intervention center, things like this. Okay. Then behavior supports for intensive intervention. Behavior supports and what we can do to provide additional behavior supports for individuals are another great resource, okay? And then the U.S. Department of Education just recently funded what's called the Progress Center. I think it's $2.5 million a year to help school districts across the nation write legally proficient IEPs. This also is based at the American Institutes of Research, and we are to the main consultants as a part of this to help write the programs in progress as a part of this. But there are some resources out there that we think are very beneficial for you.
They don't actually have a website yet. They were hoping to have it up by next week.
Yeah.
This is their mission statement, but we don't have a website to give you yet.
Yeah. So we have some. These are resources we have for you. Now did you have flyers for the Iris Center passed out? And so this is the kind of things that we want to push out. Okay. We also have flyers on other things if we like. Did you pass on the current trends ones?
Oh, here they are.
Oh, here. Oh, sorry.
But this is one of the books that Jolly has, I believe.
And this is one of the books that they have out at the front table. It's a book that just came out 4 months ago on current trends and legal issues in special education. In the interest of full disclosure, we get royalties from this, but I have a kid in college, so who wants to be a special ed teacher? Yeah, she just recently graduated. She's going to go back and get a master's and teach special ed. So it's going to go to help her be a special ed teacher. She wants to work with kids who are nonverbal, who have autism with behavior problems, who are at the secondary level. She doesn't want to work with the kids who can step on. But this is a book that Jolly has out there that we do recommend. So we have a flyer on this. You can also get that at the Amazon. And we looked at it last night. It has great reviews. So we're even pleased about this. Okay? But these are resources that we are pushing out. And we're trying to get individuals to know as much about this case. The reality of the situation is that we've seen a dramatic increase, not of formal lawsuits, but of parents filing or coming to districts with complaints. My advice to you, right? and I spoke at the National Association of State Directors of Special Education Conference on this, is my advice to you is when a parent files or leans towards a complaint, the technical term is where there is smoke, there is fire. Okay? If there's a complaint about a third grader, about an issue here, I want you to then learn from this complaint. Maybe there's another, look at all the other third graders. Look at all the other kids in the school who have IEPs. Look at all what's also going. Learn from this. Learn from this so that other kids do not suffer. And so that these things are not repeated. Again, if a parent has a complaint, whether you think it's valid or not, take it very seriously. Take it very seriously. Because too many of the districts that I'm working with right now is they look at this, they throw all the energy into the due process hearing. Which is right so, because that's the big thing that's in your face at that point. Pay attention to these things and then learn from these things. So what I do is I come into districts and I do a root cause analysis and look at what happens. Why did this thing happen? And then we try to make sure that we change the procedures. We change the staffing. We change the IEP writing. We change the training for the paraprofessionals. We change sometimes training for bus drivers. I've been involved in some pretty and nasty transportation cases of late. And so you change what's going on. Use these as learning instances so that we can help prevent additional due process hearings. Because yes, as I promised you earlier, if you have not had a due process hearing, we can get you one. We'll pass that sign-up sheet. But I want you to make sure that you understand is that just because there's a due process hearing does not mean that that's going to cause you significant problems. You need to look at everything that's going on. Use that as a catalyst for change, and then we can help solve additional problems. All right? So we have about 9 minutes left. So what I do, we'd like to take questions. And there is no question that is out of bounds. So go. Blowing through timelines. And so that's the easy get, because you can count timelines, things like this. It's just blowing through timelines. That's the first one. Second one, not having all the right people in the room. Getting the right people in the room, and this is my best advice to you, is when you get the people in the room, make sure that they actually are participating, that they're not grading or playing Sudoku, right? I mean, sometimes I have to bring my taser and taser people under the table so that they don't do those kinds of things. But get the right people in the room and learn about this. The third thing is not providing appropriate reports to regular reports to the parents. By law, we're supposed to do this anyway. That's what we're supposed to be doing, but we're not doing those things. The fourth thing is not paying attention to the data at the end of each marking period and seeing if that's being used. So what I'm doing this is going to sound much more burdensome than it is. So please just pay attention to the ending of this. I'm working with districts right now where I sit down and I have principals sit with every single teacher, every special ed teacher in their building, and they go through every single kid and every single goal. At the end of each marking period. My God, that sounds burdensome, right? No, it's not. Okay? I modeled this for a district a lot last year. We went through 25 kids in 22 minutes. It's no additional work for the teacher because they're already doing this. They have to do that data anyway. So we go through the first kid. How's he doing on this goal? Doing okay on this goal? Doing all right on this goal? Yeah. Anything else I need to know? Yeah, he sometimes comes late for school. And he's sometimes tired. Yeah, that's fine. Things like this. Everything all right? All right. Go on to the next kid. We went through 25 kids. We found 2 kids who were not making progress. We then scheduled meetings the following week to determine what could be done. Didn't necessarily require a lot of additional change, but what it did is at least we're now on the radar that we're paying attention to these. Those are the easy gets. So those procedural kinds of things like this, following these. The last thing is about reporting to parents. This is not typically what we think of as a procedural thing, is get a draft to the parent of IEPs ahead of time. All right? And it doesn't have to be like the full-blown draft. Because sometimes getting all the data and all these things is really hard, get an 80% draft to the parents so they at least have something to pay attention to. But getting that kind of thing to this. And so that they have something to look at. Whether they look at it or not, they at least have something to pay attention to. But the final thing is, and this is just the nature of adult learning. How many of you have ever been in an argument? Okay, just a few of you. The rest of you need to get out. Okay? But think about this. When you're in an argument, you can't make informed decisions. And many of you have probably been in an argument, then you roll over at 2 in the morning and you say, God, I wish I'd said that. Okay? Parents, when they come to IEP meetings, they're often put on the defensive because we're saying really negative things about their child. And then we ask them to make a decision at that meeting, and it makes it very difficult. So what I recommend for you is to assign a point person who will then contact the parents 4 or 5 days after the meeting and say, hey, we had this meeting. Do you have any additional questions or concerns that you would like to be addressed? Sometimes they do, sometimes they don't, but at least you've reached out to the parents. There's nothing in the process that tells you to do that, but it comes down to just basic human decency and being a communication person with the parent. Right? Because they can't make informed decisions, and when they've decompressed from all the negative things that they've been said about their child, they can then form a good decision, or at least form a question about why do we do this or something like this. It doesn't have to be a team decision, a point person who can then bring it back to a team, but at least you've reached out. Because most of the due process hearings I'm involved in, it comes down to just poor communication. Parents don't understand what's going on. We then ram these things through on the parents, and we don't pay attention to this. Okay? Great question.
Another thing, too, is that a few years ago, a friend of mine, myself, took a look at compliance issues across states. One of the most common is not issuing prior written notice. Very simple, procedural. That is a serious procedural error, and because that if you don't do that, effectively you're not involving the parent because you're not giving them a chance to say yes or no. That's also substantive, could also be a substantive error.
And it's free.
And
it's a free thing. It's not like it costs you anything to put that together. So that's an easy get. All right?
And a lot of, like the Walsh Law Firm in Texas, they recommend to their school districts that they take notes at IEP meetings. Some states require that.
Yeah.
So that's good. We both read many cases that tend to turn on the notes that were taken tonight.
And so I tell them, yes, building on what he said, I tell everyone at these meetings, take notes. But make sure you take notes that can be then shared with the parents so that if you bring them up to your witness stand, everything has to be shared with the opposing party. Because when I was a hearing officer, the teacher had written down great notes about what was going on in the meeting, but in the upper right-hand corner had written, parent is a devil worshiper. And so that parent very well may have been a devil worshiper. We didn't make any rulings on that. But what that did is it shut down any discussions relating to settlement. So yeah. But parents, make sure that you take notes because it forces you to also be more present in the meeting. And you should be surprised what you learn about these kids and what you have to remember. But if you go through a number of these, pull your meeting notes from like a year or two later. Oh yeah, I remember what's going on. It focuses you, pays attention. There's an app that you can get for your phone. It's, I think, called rev.com, R-E-V, where you can put your phone on the table, record it. When you're done, press upload, and then you get a typed transcript within an hour. Rev.com. A lot of my dissertation students are doing it as part of their qualitative dissertations. So they use it, and it works really well. And you get a typed transcript within an hour. Yes, you pay per page, but it's like $20 for like an hour's worth of things like this. And so it's typed, and you can get it as a PDF that you can get out to everyone. So so look up there. There are a variety of different things like this, but I use this at really contentious IEP meetings where I said, I'm telling you parents right now, I'm going to be recording this. The reason I'm recording this is then I'm going to upload it. I'll get you a copy of the transcript. And by the time you get home, we'll have the transcript sent to you. So I get the copy of the transcript, send it out, and it's the transcript. It's not my transcript. It's not theirs. It's theirs. And if there's a typo, it's them. And occasionally there's a few wordings that they misspell because it's all through verbal voice recognition. But it works really well. And so I'm recommending districts use that a lot. And so, and again, and the other thing is, because I see parents are recording these. Okay? This is the way to actually do this, or you get a transcript. This is the transcript that we got from this. And now we're seeing this admitted into hearings as here's the transcript from that discussion. And it works wonderfully as opposed to just looking at notes. But if parents then want to change notes, no. Like I have parents who want to change things all the time, and I say, because I wrote the present level statement one time that the kid, like it was just in December, the kid had already missed 45 days of school. Parent said, I don't want this in the present levels because it says I'm a bad parent. Kid had chicken pox, he'd had his tonsils out, he had all sorts of problems, and she said, it says I'm a bad parent. I said, the fact of the matter is he missed 45 days of school. It says nothing about your parenting it's a fact. We're not changing a fact. And we spent 2 hours on that. After that, it was like next 5 minutes. Let's go through the IP. All right, we're done. So yeah.
One other thing I wanted to talk about real quickly is we didn't get to that resource yet. David and I and a friend have a blog that we have out, and I'm going to actually be writing up the MC decision, not just the certain important points from it. So check that out. We'll try and change it every couple of weeks or so.
Well, the other thing is, those of you who play on the Twitter, we have a Twitter handle. It's Sped Law Blog, and and for those who use Facebook, we also have a Facebook page, Sped Law Blog, which I think I posted something there this morning. So on just some recent updates, things like that. We will not inundate you with stuff, but it's a way to get regular updates because people send us stuff. I think I posted something like 3 days ago about a survey put out by the U.S. Department of Education that wanted information about the implementation of guidelines. So, but it's just like recent cases, recent updates. But Twitter, it's Sped Law Blog. It doesn't have the .com as part of the Twitter or the Facebook thing. But we're trying to integrate the three of them together, and it's all free. This is the free stuff. Periodically, we might talk about a book that we published. By things like this, but which Jolly does have copies of. It's the Current Trends book out there. But we're going to push out as much information because we feel that informed decision making is better for everyone, and that's what we're striving for. Okay, all right. So I think that's it. All right.
Thank you, Bob.
We'll stay for questions.